Y'all hear me? Can you hear me? Can you hear me? Can you hear me? Give me a thumbs up if you can hear me, honey. Hit that like button. Share and subscribe. I guess I should be saying that, right? Let me know if you can hear me, if you can hear me. You got me? You got me. All right. Listen, I was just clicking out of grading one class, and honey, I said, let me check and see if they done put the shit in. So they done put it in. This would be a first read. Let me go and say, hey, y'all. Thank y'all for coming in so soon. Hey, Valencia, my honey. Hey, 100 devices. So thank you, Lord. Okay. Okay, I nerves been on goddamn pins and needles. Like, what do they say? All right, what up, spiritual gangsta? Jennifer, Cool BJ. Let me see. Missy, hey, my love, my love. Did I get Jennifer? Yeah, I said Jennifer. Just V, baby. Karen A, 1/3 of the KKK. Miss Move V. I got 100. Hey, Kayla. Hey, Danny. Ooh, my nerves bad, honey. Let me see. Hey, wifey. Karen J, 2/3 of the KKK. All right, I'm scanning so fast. All right, let's see what they say. Okay, let me see. Let me make a V. Full screen layout. Ooh, let's see what they said. I'm so nervous. Why am I nervous? Okay, how many pages? Oh no. All right. Okay, and this is from the government. Says the government respectfully submits this letter one in response to the defendant's September 18th, 2021 letter motion seeking an amendment of the proposed jury instructions, which includes a request that Racketeering Act 1 be dismissed, CECF number 219, and 2 seeking certain clarification and additions to the proposed jury instructions. For the reasons set forth below, with the exception of the defendant's motion as it pertains to Racketeering Act 9, the motion should be denied. Let's see what they say. Okay, the defendant's motion to dismiss Racketeering Act 1 and his request to charge reading Racketeering Act 1. The court should reject the defendant's assertions that Racketeering Act 1 be dismissed. As a preliminary matter, the defendant's request to dismiss Racketeering Act 1 is premature as the government has not rested its case in chief. Okay, so they're saying whenever they rest on Monday or whatever, then I guess that's when they say they should the defense can come back and ask for the Racketeering Act 1 be dismissed. Okay. All right. Moreover, the defendant erroneously claims that the defendant must have himself tendered the property at issue, here approximately $500 in cash, to an employee at the Illinois Department of Public Aid in order for the government to prove the defendant committed the crime alleged in Racketeering Act 1. As set forth in the third superseding indictment, the defendant is charged with committing bribery in violation of Illinois Criminal Code 5/33. We were right. We were right. We were right. I'm gonna read it. I'm gonna read it. Wait a minute. Oh, we were right. Oh, wait a minute. Shit. Okay, let me go back. Okay. As set forth in the third superseding indictment, and I'm not on the screen, y'all. The indictment, the defendant is charged with committing bribery in violation of Illinois Criminal Code sections 5/33-1A and 5/5-1. Indictment 13. Pursuant to Illinois Criminal Code section 5/5-1, a person is responsible for conduct which is an whoa, a fucking element of an offense if the conduct is either that of the person himself or that of another, and he is legally accountable for such conduct as provided in section 5/2 forth in impertinent part in section. Okay. Oh shit. Okay. A person is legally accountable for the conduct of another when B, the statute defining the offense makes him or her so accountable, or C, either before or during the commission of an offense and with the intent to promote or facilitate that commission, he or she solicits, aids, abets, agrees, or attempts to aid that other person in the planning or commission of the offense. Bim, bam, boom. They stuck to the elements in the goddamn and the superseding indictment, which I was taking the motherfucking elements from. That's what that means. Boom. We were right. Okay, let's see. Illinois Criminal Code Section 5/5-2. Accordingly, under Illinois Criminal Code Sections 5/33-1A and 5/5-1, the defendant does not need to have directly furnished the currency to the IDPA employee himself in order for the jury to find Racketeering Act 1 proven. Indeed, under the law, the defendant need not even have been. Shit, let me get my motherfucking shit together. Let me give me some water or something. Hell to the motherfucking no. We was right in the motherfucker. Okay. Where was I? Because that was choppy. What I just read. Okay. Accordingly, under the Illinois Criminal Code Sections 5/33-1A and 5/5-1, the defendant does not need to have directly furnished the currency to the IDPA employee himself in order for the jury to find Racketeering Act 1 proven. Indeed, under the law, the defendant need not to even have been present when the bribe was furnished to the IDPA employee. See Illinois Pattern Jury Instruction 5.03 and 5.06. Actual physical presence of the commission of a crime is not a requirement for legal responsibility, nor does the defendant have to provide the currency himself to an intermediary in order to be found to have committed Racketeering Act 1, as discussed above under section 5/5-1. The defendant is legally accountable for the conduct of another where he solicits, aids, abets, agrees, or attempts to aid that other person in the planning or commission of the offense. Illinois Criminal Code Section 5/5-1 and 5/5-2. Given that the defendant is charged in the indictment with committing the bribery alleged in Racketeering Act 1 in violation of Illinois Criminal Code Section 5/33-1A and 5/5-1, the government respectfully submits the proposed amended jury charge attached hereto as Exhibit A with respect to Racketeering Act 1 to ensure clarity and reflect the various matters in which the jury may find Racketeering Act proven under the law as charged, including through the use of an intermediary as well as through the defendant's own legal accountability for his conduct of another under Illinois law. The government respectfully requests that the court adopts the government's amended proposed jury instruction for Racketeering Act 1 set forth in Exhibit A. Now, we're going to go look to see if by the defense alerting the government of this, they try, to do the switch and bait shit or the elements and whatever. If the government didn't go and with the amended jury instructions, that will include a broader range of ways that they can convict R. Kelly of Racketeering Act 1. See, that might have blew up in its face. See, if they alerted the government that maybe the scope was too narrow as to how they could find him guilty of racketeering, of that Racketeering Act number one. They could have, the government could have included additional ways in order to find him guilty. Uh-huh. Oh my gosh. This one got crucial, baby. It done got nasty. Okay. Finally, with respect to Racketeering Act 1, there is currently ample evidence in the record reflecting the defendant's participation in the bribery scheme, including but not limited to testimony regarding the defendant being present in the hotel room where Demetrius Smith suggested he could bribe an employee at the IDPA. The defendant accompanying Smith and Aaliyah Houghton to the local office where the IDPA employee was bribed in exchange for a fraudulent identification card for Aaliyah Houghton. The defendant's motive for obtaining said identification and the defendant's clear control and micromanaging of the conduct of his employees and other members of his inner circle. The defendant's motion to dismiss should therefore be denied, and the government respectfully requests that the court include the attached amended instructions as part of its charge to the jury. And again, charge to the jury means jury instructions. Okay, so remember, y'all, we got to go back and look to see what they added compared to what the jury instructions already has. Okay. Number 2, the defendant's request to charge regarding Racketeering Act 8 and California Health and Safety Code, Section 120290. So it was Act 8. All right. The defendant asserts that the jury instructions for Racketeering Act 8 are wrong. Wait a minute. The defendant asserts that the jury instructions for Racketeering 8 are wrong with respect to their reference to California Health and Safety Code, Section 120290. The defendant is mistaken and relies on the wrong version of Section 120290 to assert that an amendment is necessary. The defendant quotes the version of the statute that did not go into effect until January 1st, 2018. Your bitch was right. Your bitch was right with that date. Oh, shit. What? 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 Shit. Shit. What? Okay. Woo! Shit. Okay. Okay, the defendant quotes the version of the statute that did not go into effect until January the 1st, 2018, and which is currently operative. The indictment and the court. Shit, let me get my motherfucking glasses. Hold on. Correlative jury instructions, however, makes clear that the version of Section 120290 at issue is the version that was in effect from 1998 through May 26, 2016, which covers the period in which the conduct charged in Racketeering Act 8 is alleged to have occurred, i.e. on or about between the dates, April 28, 2015 and May 1st, 2015. Whatever, let's keep going. With respect to Racketeering Act 8A, the indictment reads as follows. On or about, okay, we know what the indictment reads. Okay. With respect to Racketeering Act 8B, the indictment reads as follows. Okay, we know what that reads. Okay. Indictment 24, emphasis added. In 2015, the operative version of Section 120290, titled Willful Exposure of a Communicable Disease, provided in its entirety as follows. Hold on, y'all. Wait a minute. Sorry, y'all. I'm jumping all over the place. Okay. That motherfucking date was pivotal. Pivotal. God damn it. Okay. Title. Okay. In 2015, the operative version of Section 120290, titled Willful Exposure of a Communicable Disease, provided in its entirety as follows. Except as provided in Section 120291, or in the case of the removal of an afflicted person in a manner the least dangerous to the public health, any person afflicted with any contagious, infectious, or communicable disease who willfully exposes himself or herself to another person, and any person who willfully exposes another person afflicted with the disease to someone else is guilty of a misdemeanor. California Health and Safety Code, Section 120290, effective 1998. The text of the statute that the defendant cites, including the language regarding specific intent to transmit an infectious or communicable disease, see ECF docket number 219 at 5/6, did not come into effect until after the conduct charge in Racketeering Act 8. Okay. As a as a result, the government proposed jury charge regarding Section 120290 properly quotes the relevant portion of Section 120290 that was in effect at the time of the charged conduct and properly sets forth the elements of the charged conduct as set forth in the government's proposed jury charge at the time of the charged conduct. Section 120290 required that the defendant act willfully, not with specific intent to transmit an infection. I told you that word was willfully. Damn it. Shit. Goddamn shit. Right again. Yes. Okay. Required that the defendant act willfully and not with the specific intent to transmit an infectious or communicable disease, as the defendant's proposed instructions would require. See ECF docket number 219 at 6. As set forth in the government's proposed charge, see ECF docket number 117 at 60 and 14, both at the time of the charge, conduct, and now. California law provided that the word willfully, when applied to the intent with which an act is done or omitted, implies simply a purpose or willfulness to commit the act or make the omission referred to. It does not require any intent to violate the law or to injure another or to acquire any. Motherfucker, what? Motherfucker, who? Don't play with Club Blue. Don't do that. Don't do it. Don't do it. Okay. It says it does not require any intent to violate law or to injure another or to acquire any advantage. California Penal Code 7-1, effective until 2016. Also see a case law. Okay, the case law. Willfully implies no evil intent. The defendant proposed changes to the jury charge with respect to the intent required for Racketeering Act 8 should therefore be rejected. Oh my gosh, these people. Now, but the defense got a couple more motherfucking tricks up the sleeve. I'm going to tell you, I'm going to be just excited if they come up with some motherfucking bullshit. Because I was excited yesterday. I ain't on the screen, y'all. When I thought I was going to moonwalk them percentages back, I thought they had to slid one of the up on them and shit. But hell, these people done caught it. All right. Let's see. Okay. All right. The defendant's request to charge regarding the Racketeering Act 9. With respect to Racketeering Act 9, the defendant requests the inclusion of an instruction regarding a mistake of fact with respect to a minor's age. ECF docket number 219 at 7. The government agrees that the substance of the defendant's proposed instructions indicating that a reasonable belief that the minor was 18 years of age is a defense and should be included in the jury charge. So, they got one. Yeah. All right. So they got one. They got one. That's good. The defense got one. They got one in. Let me keep reading. The government respectfully requests a slightly differently worded instruction regarding this matter, however, as described below. So, okay, so the where are we? Hold on. So with the mistake of fact, remember that was that's what with regards to the age. That is a suit that they're saying that it will be an okay defense, which is going to be the excuse defense, which partially, it kind of mitigates his legal liability, right? So it's going to let him say that he thought that they were 18. Okay, so they're gonna let the prosecution is agreeing to it, but with it being worded slightly different. Okay, it might be a game change. I told you, them brothers Johnsons, they all right. Them goddamn attorneys all right. Go ahead on, R. Kelly. Go ahead on. R. Kelly got him one on the, and I think Sylvia was going over it the other day. So Sylvia, you got your one in, girl. You got your one in, honey. Thanks. Let's keep reading though. Let's keep reading. Let me see how it may impact it. Yeah, this is a big one. So the defense got one on in there. All right, as an initial matter, however, the government respectfully alerts the court to a typographical typographical error in the language in the indictment with respect to Racketeering Act 9, which is which is repeated in each of its subparts. Wait a minute. Okay, wait a minute. All right. Now they're talking about making changes to the indictment. Remember I talked about that this morning or last night, that you could do that with the information, but you can't do that with the actual count or the charge itself. Okay, so let's see what it says. All right, let's see. Okay. Okay, Racketeering Act 9, which is repeated in each of its subparts, which the government respectfully submits that the court should correct. Okay, specifically in Racketeering Act 9A, 9B, 9C, and 9D, there is a typographical error in the final to wit clause for these acts. Oh. Wait a minute. Those paragraphs currently state in relevant part that the defendant either transported or coerced, enticed an individual who had not yet attained the age of 18, Jane Doe number 5, to travel. Boy, Jane Doe number 5 giving them all kind of motherfucking hell. Woo! In interstate commerce, with intent that such individual engage in sexual activity for which a person can be charged with a criminal offense, to wit, violations of California Penal Code sections 261.5A and 261.5B, unlawful sexual intercourse with a person under 18 years old, and that Kelly engaged in sexual intercourse with Jane Doe number 5, who was under 18 years old, while he was more than 3 years older than Jane Doe number 5, in violation of federal law. Indictment 26 through 29, emphasis added. The typographical error is in the citation to section 261-5B, which, as the rest of the language in the relevant paragraphs make clear, is in error and should be corrected to cite section, section 261-5C. The relevant portions of section 261-5 of the California Penal Law are set forth. Wait a minute. Now, is this an amendment to the actual law, the charge, or is this amendment to the information? Like, wait a minute. Oh, that's all right. Never mind. I'm straight. I'm tripping for nothing. All right, this is with respects to the jury instructions. This is not re- to make changes to the indictment. Okay, let's wait a minute. Let's make sure. Instructions. Okay. Now, here's the thing. If they make this change to the jury instruction, will that match the indictment? So is the indictment right and the jury instruction currently wrong? Somebody write that down because we're gonna figure it out. Let me write that down. Is indictment language? I'm sorry, y'all. You know how we do it. Okay, in versus jury language. Okay, we're gonna find out. Um, something else with that. Okay. 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 The relevant portions of Section 261.5 of the California Penal Law are set forth below. A. Unlawful sexual intercourse is an act of sexual intercourse accomplished with a person who is not the spouse of the perpetrator, if the person is a minor. For the purposes of this section, a minor is a person under the age of 18 years, and an adult is a person who is at least 18 years of age. B. Any person who engages in an act of unlawful sexual intercourse with a minor who is not more than 3 years older or 3 years younger, that the perpetrator is guilty of a misdemeanor. C. Any person who engages in an act of unlawful sexual intercourse with a minor who is more than 3 years younger than the perpetrator is guilty of either a misdemeanor or a felony and shall be punished by imprisonment in a county jail, not exceeding 1 year, or by imprisonment pursuant to subdivision H of section 1170. Okay, let me tell you. Let me stop right here and tell you. So, if we go back and see that by changing that jury instruction, it's going to be different than the indictment, the defense may come back and say, well, that means that my client can be convicted wrongfully, right? Because the defense gonna have something. Woo, it's getting good now, baby. So the defense can. I mean, shit. I don't know. I'm letting them know what they're doing. Shit. I guess they would know what they're doing to ask to make that change. I mean, it has to. That jury instruction got to reflect what that indictment says, right? I ain't on the screen, so I don't know. I don't know what y'all saying. But if they change this motherfucker and it don't match what the indictment says, he gonna come right on in there and then gonna probably ask that for it to be dismissed. And then again, I told you when you talking about getting indictments and shit like that, again, it got to deal with the leave of court. It got to deal with you might run into a statute of limitation issues and definite double jeopardy issues. So this is getting crazy. This is the wild wild fucking west. Okay. Or the wild wild north. Oh my gosh. Okay, let's go. All right. It says California Penal Code section 261.5 A through C. The indictment correctly cites to section 261.5A. Oh, okay. Okay. If I'd have kept on reading, I would answer my own fucking question. Okay, it says the indictment correctly cites to section 261.5 point 5A, which defines unlawful sexual intercourse with the minor. The indictment erroneously cites to Section 261.5B, which is the subsection that applies if the minor is within 3 years of age of the perpetrator. This is clearly a typographical error, given that the indictment immediately thereafter provides notice of the specific conduct at issue that the violative of Section 261.5 stating in that Kelly engaged in sexual intercourse with Jane Doe number 5, who was under 18 years old, while he was more than 3 years older than Jane Doe number 5. Okay, all right. Yeah, why y'all didn't tell me if I highlight it, I could see it better? Shit. Okay, so that is a typo. Okay, because it was finna get funny. The defense was finna slide some shit on in there. Okay, because they don't miss shit. All right. In violation of, and see, this goes to show you, everybody makes mistakes. It don't matter how long you done sat your ass in those people class and been on the floor doing this shit back and forth. Everybody makes mistakes because they know damn well R. Kelly ain't wait a minute, hold on. Who is under 18 years wide? Well, that would be kind of right though, in that Kelly engaged in sexual intercourse with Jane Doe number 5, who was under 18 years old, while he was more than 3 years. Well, is it supposed to say 5 years? Is this Illinois state law or California? Okay, well, never mind. In violation of federal law. Indictment 26.29, emphasis added, Section 261.5C is the provision that applies in such circumstances. See California Penal Code Law, Section 261.5C. Any person who engages in the act of unlawful sexual intercourse with the minor who is more than 3 years younger than the perpetrator is guilty of a crime. Engages in an unlawful sexual intercourse with a minor who is more than 3 years younger than the okay. The government respectfully submits that the court should correct this typographical error in the indictment and amend the jury charge accordingly. Okay. All right. Long as it was already in there, okay, and they in the indictment, and they're just amending the typo, then the indictment should be valid, right? Okay. Because we talked about this yesterday, the potential stuff that could happen, and now you're seeing how they're trying to, get it together. Okay. Sorry, y'all, for this rough read. You know how I do. Okay. The government respectfully submits the court should correct this typographical error in the indictment and amend the jury charge accordingly. See U.S. versus Denisha case law. All right. The requirement that the grand jury amend the indictment is not absolute. The district court or the prosecutor may make ministerial changes to the indictment, such as to correct a misnomer or a typographical error. Altercation in the original. Hold on. Case law. Prosecutor may move for a minor correction of an indictment because the correction of merely technical errors such as typographical or clerical mistakes is permissible where it does not alter the essential substance of the charging terms, meaning it does not mess with the elements. Okay, so that is what I was telling y'all about, fooling around with the indictments and stuff like that. You can't do that. You can't amend, the actual elements in the indictments and shit like that. Just some of the information. Okay, and there's a case law. Okay, that case law held that the amendment by the court of citation and indictment appropriate where indictment mistakenly cited wrong subsection of 18 USC section 924 and indictment provided notice in its language as to correct subsection. FRE crime P7C2 citation error unless the defendant was misled and thereby prejudiced. Neither an error in a citation nor a citation's omission is grounds to dismiss the indictment, okay, or information to reverse a conviction. Given the clear language in the indictment, the defendant had ample notice of the violative conduct at issue, and the requested typographical correction does not alter the essential substance of the charge and terms in any way. With this typographical error corrected, the government respectfully submits that the following jury charge with respect to Racketeering Act 9 should be used, which incorporates the substance of the instruction requested by the defense counsel. Okay, so I should be used, which incorporates the substance of the instructions requested by the defense counsel. Okay. The indictment provides that the defendant violated California law by engaging in sexual intercourse with Jane Doe number 5, who was under 18 years old, while he was more than 3 years older than Jane Doe number 5. California law provides that any person who engages in an act of unlawful sexual intercourse with a minor who is more than 3 years younger than the perpetrator is guilty of a crime. Unlawful sexual intercourse is an act of sexual intercourse accomplished with a person who is not the spouse of a perpetrator if the person is a minor. For these purposes of this section, a minor is a person under the age of 18 years, and an adult is a person who is at least 18 years of age. To prove a violation of this provision of California law, the government must prove that the defendant had sexual intercourse with Jane Doe number 5. The defendant and Jane Doe number 5 were not married to each other at the time of the intercourse, and at the time of the intercourse, Jane Doe number 5 was under the age of 18 and more than 3 years younger than the defendant. Sexual intercourse means any penetration, no matter how slight, of the vagina or genitalia by the penis. Ejaculation is not required. It is not a defense that Jane Doe number 5 may have consented to the intercourse. Okay, okay. Defense, good faith belief 18 or over. The defendant is not guilty of this violation of California law if he reasonably and actually believed that Jane Doe number 5 was age 18 or older and at the time of the charged intercourse. Okay. The government must prove beyond a reasonable doubt that the defendant did not reasonably and actually believe that Jane Doe number 5 was at least 18 years old. Okay, the defense got one on in there. Okay, 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 yeah, okay. So, all right, Mr. Goddamn, Shola, whatever the hell your name is, put it on in there. That's what I'm talking about. Shit. Team Kels, give him hell. Yeah. All right, he got one on in there now, baby. So now he can go ahead and argue that I Kelly thought she was 18 on Jane Doe number 5. He can argue that he got the lies. He can argue all that, the other little stuff. He can argue that. He really can. Go ahead on now. How long is this shit? Wait a minute, let me see. Okay. All right, Racketeering Act 3. The government also submits amended and supplemental language to its proposed jury charge regarding Racketeering Act 3. Similar to Racketeering Act 1, Racketeering Act 3 charges that the defendant committed the alleged offense. alleged offense in violation of Illinois Criminal Code 5/10-1 and 5/5-1. Accordingly, the government proposed amended jury instruction attached as Exhibit C reflects accountability liability as charged in the indictment under Illinois law. The government respectfully requests that the court adopts the government's amended proposed jury instruction for Racketeering Act 3 as set forth in Exhibit C. All right, where's Exhibit C? Okay. Racketeering Act 5. Finally, the government respectfully requests that the court add the following language to the jury instruction for Racketeering Act 5 after the sentence. Evidence of emission of semen is not required to prove sexual penetration. Huh. It is a defense to the charge of aggravated criminal sexual abuse that the defendant reasonably believed that Jane Doe number 4 to be 17 years of age or older at the time the acts of sexual penetration were committed. Okay, well they done slipped them a damn little something in here, and for it to be changed on the charge. Okay, wait a minute. Hold on. Okay. All right. Request number 16, the Racketeering Act 1 bribery. All right. Racketeering Act 1 charges defendant with bribery. It reads, on or about August 30th, 1994, within the Northern District of Illinois, the defendant RSK, together with others, did knowingly and intentionally cause another individual to promise and tender to a public officer and public employee property to wit, Lord, United States currency that such public officer and public employee was not authorized by law to accept with the intent to influence the performance of an act related to the employment and function of a public officer and public employee to wit, the creation of a fraudulent identification document for Jane Doe number 1, an individual whose identity is known to the grand jury in violation of Illinois Criminal Code Section 5/33-1A and 5/5-1. The Illinois Criminal Code Section 5/33-1A provides in pertinent part that a person commits bribery when, with intent to influence the performance of any act related to the employment or function of any public officer or public employee, he promises or tenders to that person any property which he is not authorized by law to accept. In order to prove that defendant committed the crime alleged in Racketeering Act 1, the government must prove beyond a reasonable doubt each of the following three elements: that the defendant or one for whose conduct he is legally responsible sought to influence was a public officer or a public employee, and the defendant or one for whose conduct he legally responsible promised to tender property to the public officer or public employee, the defendant or one for whose conduct he is legally responsible sought to influence, and 3, that the defendant or one for whose conduct he is legally responsible did so with the intent to influence the performance of any act related to the public officers or public employees' employment or function as a public officer or public employee. Let me look at something real quick. Okay. Hold on. Okay. Exhibit A. Okay. In the alternative, the government may also prove that the defendant committed the crime alleged in Racketeering Act 1 if it proves beyond a reasonable doubt each of the following two elements. First, that the defendant or one for whose conduct he is legally responsible promised or tendered property to another individual, and that the defendant or one for whose conduct he is legally responsible did so with the intent to cause another individual to influence the performance of any act related to the employment or function of public officer or public employee, and the persuading precedent authority. Okay, when account was an issue, I never insert the phrase. Okay, hold on, y'all, because I want to make sure I get this right, get it to you right. Cause okay, so they did do what I said they was going to do. They went ahead and made it. Let me see, more broader for the jury instructions, right? So now what they did was, I'm gonna read it and then I'm gonna explain to you. It says, this is the precedent. Okay, it says Illinois pattern jury instructions, criminal, and all those numbers. Okay, it says when accountability is an issue, ordinarily insert the phrase or one for whose conduct he is legally responsible after the word defendant in each proposition. Case law. A mere offer or promise with requisite intent is sufficient to constitute bribery under Illinois law. So, like I said, they was going to do early on when I went to reading it. Now, remember, I said I hope they didn't tip them off to where they made it broader, right? That way, they now have added they're asking to add in. Now, this hasn't been you know allowed yet, but it says when accountability is an issue, ordinarily insert the phrase or one for whose conduct he is legally responsible after each word of the defendant, meaning he's going to be responsible for Demetrius Smith's conduct. That's what it means. So what Kent and them tried to do is say it was Demetrius who found a person and gave the people the money and blah 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 blah. The government saying they want that added, so they're saying, okay, for that R. Kelly is responsible for Demetrius' conduct. See how this shit works? So that kind of backfired on if this goes through, it kind of backfired on the defense because now the government is asking to make it broader. And it is also citing something from the same type of persuading precedent that the defense used to make its argument, right? That Illinois pattern jury instruction. So it's using that. So now they're placing the defense and the prosecuting now is placing this square. Well, it's going to be square on the shoulders of the judge anyway. But now they are using, like, they're competing with the same sort of persuading precedent. So this is going to be interesting how this turns out. Okay, let's see. Let me come around. Let me see if y'all got any of that I'm talking about. Did y'all get any of that I'm talking about? Did y'all get any of that? I'm on the screen now. Y'all got what I'm trying to say? Okay. So I'm gonna make sure y'all got what I was trying to say. All right, let me go and go on the side. All right. It says Illinois Criminal Code Section 5/5-1 provides in pertinent part that accountability for conduct of another. See, if I would have kept reading, I could have probably explained to you, better because they got a better explanation. Accountability for conduct of another, A person is responsible for conduct which is an element of an offense if the conduct is either that the person himself or that of another, and he is legally accountable for such conduct as provided in Section 5/2 or both. It says Illinois Section 5/5-2 provides in pertinent part that a person is legally accountable for the conduct of another when B, the statute defining the offense makes him so accountable, or either before or during the commission of an offense and with the intent to promote or facilitate that commission. He solicits, aids, abets, agrees, or attempts to aid that other person in the planning or admission or commission of the offense. When two or more persons engage in a common criminal design or agreement, any acts in the furtherance of that common design committed by one party are considered to be the acts of all parties to the common design or agreement, and all are equally responsible for the consequences of those further acts. Mere presence at the scene of a crime does not render a person accountable for an offense. A person's presence at the scene of a crime, however, may be considered with other circumstances by trier of fact when the let's see, okay, so mere scene of a crime presence at may be considered with circumstances. Okay. A person is not so accountable, however, unless the statute defining the offense provides otherwise. If he is a victim of the offense committed, the offense is so defined that his conduct was inevitably, inevitably incident or its commission or before commission of the offense, he terminates his effort to promote, facilitate that commission, and does one of the following: wholly deprives his prior efforts of effectiveness in that commission, gives timely warning to the proper law enforcement authorities, or otherwise make proper effort to prevent the commission of the offense. I further instruct you that with respect to Racketeering Act 1, the defendant is legally responsible for the conduct of another person when either before or during the commission of an offense and with the intent to promote or facilitate the commission of the offense, the defendant knowingly solicits, aids, abets, agrees or to aid or attempts to aid the other person in the planning or commission of the offense. Actual physical presence at the commission of a crime is not a requirement for legal responsibility. Intent to promote or facilitate the commission of the offense may be shown by evidence that the defendant shared a criminal intent of the principal or evidence that there was a common criminal design. A person who is legally responsible for the conduct of another may be convicted for those offenses committed by the other person, even though the other person who is claimed committed the offense has not been prosecuted or has not been convicted of the crime. Let me reread that. A person who is legally responsible for the conduct of another may be convicted for the offense committed by the other person, even though the other person who it is claimed committed the offense has not been prosecuted or has not been convicted of the offense. Okay. Okay. Office section. Okay, so this is more blah blah blah. Okay, this is okay. Okay, wait a minute. Okay, the for whose conduct legally responsible normally. God damn, they asking for wait a minute, they asking for more shit. Wait a minute, they asking for some more stuff. Hold on. Wait a minute, I thought I was done. Wait a minute. Hold on. Let me see how much they asking for. Okay, wait a minute. They asking for something to be done. Oh, let me get me some water. Y'all give me a minute. Let me get me something to drink real quick. Oh, let me come back around the front real quick. I'm gonna drink this. I'm gonna get back to reading because they are asking for some more shit. Hold on now. Yeah, I'm back on the screen now. So what y'all think? Like what is going on? Because I don't think that they hold on. While I'm sitting here looking at y'all, I'm on the screen. While I'm sitting here looking at y'all, I'm finna pull up that last what the defense asked for because I don't know if the prosecutors are now trying to cover their ass because they look like they have made some mistakes and shit like that. So they trying to, while this is in front of the judge, you know, brought to her knowledge by through a motion by the defense. I think the prosecution must be saying we got some stuff that we need to correct. So let me go in here and see. I'm on the screen with y'all. Let me go in here and see what was the actual request from the defense because I don't remember all this. Shit. Ooh, but we was right, honey. We was right. I knew it. I'm over here. I'm not on the screen no more. I'm over here pulling up what was submitted yesterday. I'm gonna look at it real quick. I'm not on the screen, so let's see. They needed something done to Act One. I know I wasn't crazy. Yeah, they need something done to Act One, and they need the mistake to fact. The government, they trying to get something done to Act. Okay, now they getting caught with they goddamn uh shit. Hell, wait a minute now. See, the judge probably gonna be cussing. Okay, Act Three. See, they need something done to Act Three. Kidnapping. Hold on. This is crazy. What they want done to kidnapping? All right, let me see what y'all talking about. Let me see what y'all talking about. I'm on the front. I'm just drinking this soda before I get in to see what they want done to kidnapping. This is absolutely nuts. This is absolutely nuts. But let's see what they say about the kidnapping. Let's see. All right. It says Racketeering Act Three, the kidnapping. It says Racketeering Act Three charges defendant with kidnapping. It reads in or about between 2003 and 2004, both dates being approximate and inclusive within the Northern District of Illinois and elsewhere. The defendant, Robert Sylvester Kelly, together with others, did knowingly and intentionally secretly confine an individual, to wit, Jane Doe number three, an individual whose identity is known to the grand jury, against her will, and introduced Jane Doe number three by deceit and enticement to go from one place to another with intent secretly to confine her against her will in violation of Illinois Criminal Code Section 5/10-1 and 5/5-1. Illinois Code Section 5/110 one provides in pertinent part that kidnapping occurs when a person knowingly and secretly confines another against his will, or by deceit or enticement includes another to go from one place to another with intent secretly to confine her against her will. The government must prove beyond a reasonable doubt each of the following elements. First, the defendant, or one for whose conduct he is legally responsible, acted knowingly, and the defendant. Okay, so they just want that same thing added in there. So, I guess they're alleging that maybe him and or someone else was behind this alleged kidnapping of who that is, Jane Doe number. Let me see. Racketeering Act Three just says. Let me see. It says Jane Doe number three. Okay, so confinement is established where the victim has been clearly enclosed within something, most commonly a house or a car. The secret confinement element of kidnapping may be shown by proof of the secrecy of either the confinement or the place of confinement. Put another way, confinement is secret where it serves to isolate or insulate the victim from meaningful contact or communication with the public. That is, when the confinement is in a place or in a manner which makes it unlikely that members of the public will know or learn of the victim's unwilling confinement within a reasonable period of time. And so they list the authority. Okay, it says, as I previously explained to you, and with respect to Racketeering Act 1, um, okay, talking about accountability. So they're just making R. Kelly responsible for someone's action, another person's actions, like Demetrius. So whoever was involved in this alleged kidnapping, that's what they are saying. Okay, so a person is responsible for the conduct, either with during the commission of an offense, with intent to promote, facilitate, commission, blah blah blah, with two or more persons. The same. Okay, this is the same thing. They're just repeating. A person is not accountable, however, unless the statute defining the offense provides otherwise. Okay, so a person is not accountable, however, unless the statute defining the offense provides otherwise. So the offense, the charge, the element has to say that a person is accountable for someone else's action with regards to that charge. So that they're trying to make R. Kelly responsible for everybody. Everybody. I further instruct you that with respect to Racketeering Act 3, the defendant is legally responsible for the conduct of another person when either before or during the commission of an offense. and with the intent to promote or facilitate the commission of the offense, the defendant knowingly solicits, aids, abets, agrees to aid, or attempts to aid the other person in the planning or commission of the offense. Right. And it just goes on to repeat the same stuff. And we to the bottom of that. Okay. So, yeah, that's what they're doing. So, I'm on the screen, y'all. So, what y'all think about that shit? What do y'all think? Yeah, yeah. They try to make him responsible for everything. But so just so y'all we get the tally sheet right. So and the judge hasn't ruled, of course. So the judge hasn't ruled, of course, but let's make sure we get this tally sheet right. Won't get it right. So the let me see. Racketeering. Okay, so there's not go. So she most likely gonna let him do this mistake of fact for the H. The prosecution is still opposing whatever they say to the STD, and the prosecution is asking the judge to make him responsible for um, other people's actions with regards to those specific counts, right? So that makes it, this is going to be crazy. Right, Mocha. Yeah. I mean, yeah, but do you see y'all see how they like both sides kind of, well, I'm not going to say the defense pretty much left stuff out because they didn't, because it's the prosecution's um indictment. You know what I'm saying? So it was no error on the defense. The defense is doing what they should be doing. But now they got some traction on that Jane, with Jane Doe number 5 on that age thing with those particular accounts that they cite. So this is gonna be different. Now they have a little mojo with their defense, right? With their excuse defense. They got a little mojo. Oh man, Bear, I still have to, I gotta stay at 91 because now I got, okay, so the prosecution is going to concede somewhat with the mistake of fact, right? That's huge for the defense. But then the prosecution also want them to include to make R. Kelly responsible for the actions of others. Well, I can't move off 91 with that because I can see her grant the mistake of fact, right, for the defense. Think hard a little longer about adding that language in there. And I didn't, go through the authority on that to read how it's listed, but it should have been included before. So I don't know. I do not know. Right. But when it comes down to the actual, okay, him being, you know, responsible for the entire enterprise, yes. But it gets down to being crime specific. What are the crimes, right? And hold on, let me see if they are asking. Wait a minute, let me see. I don't think that language is in the indictment. Hold on. I don't think that language is in the indictment. What the indictment reads. Hold on, let me see something. They're talking about them herpes. I'm so tired of reading about them damn herpes. Let me see. I'm just looking to see that they say that that language is in. It reads. Okay. Yeah, it's not in that indictment like that. So I don't know about that. I don't know about that. Well, that's beyond my pay grade. I don't know about that, baby. I do not know. Hey, I don't know. Shit. Mm-mm. Listen here. Y'all better stop playing with that defense and put some respect on their name. They are not playing with you. They ain't playing. Shit, I knew that shit went to catch yesterday. And they called it, but look at they want to add some other stuff to it. No, she is going to. Hmm. So that indictment don't read like that. That's the problem. I don't know. It may not be a problem. I don't know. It may not. Hey, they shit. If she grants, I mean that's up to her. You know what I'm saying. So, but it's big. The government must be really believe that they have had enough evidence to say that R. Kelly knew how old Jane Doe number 5 was. I don't know, y'all. But yes, honey, it came on in. It came on in. So, well, yeah. So I'm gonna get back to what I was doing. I just wanted to pop on here to see were we right. You know what I'm saying? And of course, honey, yes, yes. Down to the damn date, child. Down to the date. Head of HR fix what? What she got to fix? It has right. Okay, look at Smoothie using the language. I know that's right. I'm going through y'all comments. I'm looking. Yep, y'all got it down pat. I just wanted to read that to see. But that's crazy that they would make those mistakes like that. That's crazy. No, I guess we got to listen to the news. Yeah, so everybody, y'all be listen to the goddamn news and stuff like that to see, and the articles and stuff like that to see if she addresses it in court. 'Cause I ain't got time to wait for no goddamn transcript. I need her to address it tomorrow. Hey, we ain't got time for this. I want to know who is winning and what is the prize. That's what I want to know. Who is winning? Yeah, but that's pretty good though. You going tomorrow, Queen Diva? Okay, well, can you let us know or report back of what you want to do? If you email me, I'll go live and let you tell us what happened. I need to know. If you want to email me or call me, where's the number? Oh, right. Okay, you got my email already? And one of them phone numbers? Hey, non-lawyer, what it do? What it do? Mm, look like, look like the, hey, that was pretty good. That was pretty good. That was huge for that defense to get. Well, I'm just saying that not like I said, normally if both the defense and the prosecutor agrees with change or whatever, the motion or whatever, they'll she'll go ahead and put it in. So that's why I'm assuming that she's gonna let them you know use the mistake of fact as a the right. Is she gonna let the prosecution amend that language and that jury instruction? Cause and see and here's the thing, right? Remember, the defense asked for the jury instruction to read not guilty and not proven, guilty and proven, right? If that language for it to include like R. Kelly is responsible for the acts of the other people, if the jury don't say that they can honestly say that he's responsible for that, then that charge won't be proven. This is why it makes a difference. I felt when the judge told Geddes that she didn't want to tell her she was over her head, they counseled to the fact that it was obvious. Honey, I don't know. So I'm gonna get back to work. just wanted to pop in and get y'all that real. I'll try to go over it, so I'll see if I can catch some other stuff. But I went through it pretty well. I know I sped through it, but I went through it pretty well to see, what I could see and to see if we were right on what we were talking about. So yeah, we on target with it. We're on target. We're on target. We just got to know what Judge Ann say. Shit. I mean, she need to be working tonight to tell us. Cause hey, if she put it in at 2 o'clock, and if I get it, I'm gonna roll right on over and hit the button. I ain't gonna be even set up. I'm just gonna hit the live button. I got to give it to y'all so I can go and get out of here. So okay, so let me go and finish working, y'all. If something else come on through, baby, I'll come on go live. All right, y'all. Peace out. Thanks for coming on through.